Our proposed defense of the claim absorbed another blow when Pickens admitted to having been an employee of Universal Megacorp and an occasional consultant, as well as a personal friend of the local manager. Universal had even worked with him as cost consultants on the design of this project. The architect saw no problem with any of this. Welcome to The Claims-Free Architect, the podcast that helps architects understand risk and protect themselves and their practice from claims by learning crucial lessons from our archive of over 6,000 past insurance claims. The Claims-Free Architect is produced by Prodemnity Insurance Company, whose cause is to champion architects' wise, efficient, and effective management of risk and build thriving practices. What is the significance of the disclaimer? Owner is not obligated to accept the lowest or any bid, as interpreted by the architect, the owner, the bidders, and the courts. Being demonstrably fair and transparent in the bidding process is crucial. Playing favorites or changing the rules at the last minute can lead to serious trouble. When bidders feel cheated, they may take it personally, and what seems like a small decision can create an expensive lawsuit. Help your colleagues protect your firm from allegations of errors, omissions, or negligence that may arise from the practice of architecture by sharing the wisdom from our stories. All you have to do is share this episode with one or more colleagues and let them know they can subscribe to our feed in their favorite podcast app. In a conventional design bid-build project, the design phase and the build phase account for the lion's share of the architect's work and the architectural fees, by far. The bid phase that connects design and build may appear to have little significance, but when it is mismanaged or misunderstood, its importance becomes apparent with financial and reputational consequences. In this story, an architect and his client are accused of bid mishandling when a contract is awarded to the highest bidder. The lowest bidder files a claim, alleging that the sanctity of the bidding process has been violated. We call this story Bidding Bungle. WD&M of Canada is a business organization with a large membership of influential companies. As a monument to their industry and to their own high ideals, the organization had decided to build new headquarters. To realize their aspirations in iconic form, they commissioned Pickens & Chu architects. The design and documentation went without a hitch. Tender documents were prepared and 6 contractors were invited to bid the job. The award went to the highest bidder. The lowest bidder sued. Most tender documents include a privilege clause, which states, the owner is not obligated to accept the lowest or any bid. This may seem a little offhand, even unfair, rejecting any or all bids on a whim, especially given the amount of effort that bidders expend preparing a complicated bid and carving the costs down to the bone. Also, there is substantial case law in Canada that challenge the very validity of this clause. Do owners and their architects deserve to have this privilege when it might cast doubt on the fairness of the process? Business dealings that are unfair or appear to be unfair can often generate animosity at a personal level, and the lowest bidder, Acme Contracting, was incensed, a fact that was reflected in the language of the notice of claim. As soon as Prodemnity received it, the claims specialist thought it wise to interview the architects as soon as possible. Graham Pickens, the project architect, explained that of the 6 invited bidders, only 3 submitted tenders were considered compliant. he had presented those 3 tenders to his clients WD&M and their lawyers, while the estimators of the 3 bidders waited for the results in an adjacent room. After careful analysis, Pickens concluded that Acme Builders had submitted the lowest bid. WD&M accepted this conclusion and announced the bid amounts to the 3 estimators, declaring Acme as a successful bidder. The process might have ended there, however. Pickens initiated a discussion among all those present regarding suggested alternatives. He proposed that the 3 bidders come back in 5 days with separate estimates for the changes. Pickens recalled that there had been no objection to this proposal at the time. The owner saw an opportunity to get the prices whittled down a bit, and 2 of the estimators saw it as a chance to maneuver their bid into a winning position. Surprisingly, the 3rd estimator, representing Acme, seemed happy to conform to the plan, possibly believing that Acme's winning position was secure, or perhaps failing to believe that the other bidders would use this opportunity to manipulate the process to their advantage. In any case, 5 days later, when the alternative quotes were submitted and the totals were recalculated, the initial lowest bidder, Acme, moved to 2nd place, and the original highest bidder, Universal Megacorp, moved into position as the lowest bidder. The job was awarded to Universal Megacorp. This raises a thorny issue. There are conflicting views regarding how to deal with the price of alternatives in evaluating bids. In one method, only the base price is used in determining the lowest bid. Any alternatives or changes are negotiated with the winning bidder after the contract has been awarded. A second method considers both the base bid and the alternatives when determining the tender amount before the contract is awarded. This may seem more effective, but under certain circumstances, it can lead to a manipulation of the process. For this reason, the first method is normally recommended as the most transparent, hence the fairest. In this case, for example, the 2 losing bidders were made aware of what price they had to beat when the original verdict was announced. They were then given an entire business week to win back the project by trimming their price through possibly undervaluing their alternatives. The bidders were never informed what alternatives were accepted and at what price. Acme, in filing their claim, took the first position, that the low bid, which should be the basis for awarding a job, refers to the lowest quotation before any negotiation of alternative prices. The low bidder should only be excluded if, prior to the submission, substantial doubts arise regarding their ability to perform. So, despite their previous agreement to the resubmission plan, Acme, now sadder but wiser, was declaring the whole process corrupt. And they may have had a legitimate gripe. By most standards, Acme, as the lowest bidder, should have been awarded the contract, or at least given the chance to negotiate any savings or alternatives contemplated by the owners. Instead, they had lost the opportunity to do the work, along with their investment in the bid process and any profit potential from the project. But Acme wanted more. They had been treated unfairly and needed to make a point. They were seeking punitive damages to compensate for unconscionable favoritism in the awarding of the bid to a friend of the architect, not to mention the various corporate insults that had been offered as reasons for not awarding them the contract, despite their legitimate low bid. The winning bidder, Universal Megacorp, had little to say, except that they were blameless. The claims specialist had to ask himself, how credible was the architect's story? Would a low bidder willingly agree to such a bid resubmission process knowing that it might cost them the job? Would a court believe that it was all entirely above board? The story became even stickier when the architect admitted that he was the one who had decided which alternatives to use in calculating the final price. He had neglected to point out to the owners that by choosing clay tile here, concrete block there, this finish in the conference rooms instead of that one, he could have probably given the low position to any of the three, not forgetting that the owner is not obligated to accept the lowest or any bid. It also wasn't helpful that the client, WD&M, was greatly relieved by the decision because Universal was a large company well known to their members, while Acme was a small operation that had, it was rumored, an iffy reputation. Universal was a more convenient choice and probably their preferred bidder all along. Universal's lower bid was the justification they needed, but had the sanctity of the bid process been compromised along the way? Our proposed defense of the claim absorbed another blow when Pickens admitted to having been an employee of Universal Megacorp and an occasional consultant, as well as a personal friend of the local manager. Universal had even worked with him as cost consultants on the design of this project. The architect saw no problem with any of this. He was innocent despite the evidence. He had acted honestly, without favoritism, and had consulted with his clients and their lawyer at every opportunity. He was certain that they would stand by him and vouch for his integrity. When the interview ended, Prodemnity Counsel agreed to contact WD&M Counsel and obtain a deposition that the architect was merely carrying out the wishes of his client and had relied upon legal advice offered by their lawyer. It came as no surprise to the claims specialist when he received a distraught call from the architect a few days later. Pickens reported that he had called each of the half-dozen WD&M committee members present at the bid opening. They all remembered that they had relied upon his advice, but had no clear recollection of anything else that went on. The call to the client's legal counsel was equally disheartening. Had the architect dreamed his story up? Probably not. But credibility was becoming an issue. Our defense of the architect was going to be tricky. Did we even have a legal leg to stand on? First, there was the issue of the right to reject or accept bids at will. There is case law that seems to throw this hallowed concept into doubt. Then there was the allowance question. Should they be factored into the lowest price decision, or should the contract be awarded to the lowest base bid, with the alternatives negotiated later? In either case, owners would appear to have the right to reject any item in favor of another, on a mere whim, like a shopper in a retail mall. We couldn't overlook the obvious pall of favoritism that hung over the entire process. What would happen if the evidence led to a reasonable conclusion that the contract award was a fix between Pickens and his pal, the contractor? Acme wanted punitive damages, and they might be awarded, but pro-indemnity policies don't cover such things. Furthermore, criminal charges could follow if the matter were brought to the attention of the Crown prosecutor. It looked to us like an unappetizing defense position, one from which we could not come out a winner. If the trial judge agreed with the plaintiff, we could imagine a future professional landscape consisting of endless bad faith claims where bids were alleged to have been rigged. At the same time, our position was at odds with our own best interests. By defending the indefensible, we might be eroding the profession, as well as the entire construction industry. The bidding system only works if it's seen to be more or less fair. Otherwise, contractors won't be prepared to gamble away the considerable costs of putting a bid together. A no-win situation stared us in the face. Ultimately, we would have to pay the freight. When we pointed these serious issues out to the architect, and it was not an easy conversation to have, he was deflated and angry. But he reluctantly succumbed to the reality of the situation. He still claimed total innocence, but he saw that the preponderance of evidence pointed towards liability. He agreed to do whatever Prodemnity recommended, as long as it got him out from under. Through patient negotiation, Prodemnity Counsel was able to avoid court and placate the plaintiff with a very modest payment. The cost of the bid, legal fees reimbursed, and a little extra for face saving, no loss of profits, punitive damages, or prejudgment interest, just enough to constitute a moral victory for Acme, with out-of-pocket going back into pocket. Architects are excellent rationalizers. It's part of the job, and it's an important positive quality. But sometimes the belief that one is doing something for the worthiest purpose can cloud judgment rather than clarifying it. With this in mind, there are two useful lessons to be gleaned from this story. Lesson number 1. In this story, the architect, hoping to achieve the most favorable outcome, had failed to see the situation as others might see it. The architect was a friend of the initial high bidder and managed to reorganize things in such a way that his friend got the job. This perception may be far from true, but in the tendering process, any hint of favoritism is to be avoided at all costs. Lesson number 2. Fairness is important, but it's sometimes more important to be more than fair. Lawyers use the phrase contra pro ferendum, which, as any lawyer will be happy to tell you, should be at the front of every architect's mind, especially when a conflict of interest may be alleged. The rule says this: when ambiguity exists in an agreement, the more favorable interpretation will never go to the person who created it. In other words, the person who slices the cake doesn't get to choose the first piece. If it helps you to remember it, this doctrine is sometimes referred to as interpretation against the draftsperson. The draftsperson might turn out to be you. Thank you for listening to this edition of The Claims-Free Architect. We hope it was instructive and entertaining, and that it might help you be proactive in managing liability risks in your architectural practice. In this episode, we've learned that in the tendering process, any hint of favoritism is to be avoided at all costs, and that according to the rule of contra pro ferendum, when ambiguity exists in an agreement, the law will rarely side with the person who crafted it. Remember that every jurisdiction and every case is different. Always refer to the laws and regulations governing your local jurisdiction and consult legal, architectural, and insurance professionals about the unique circumstances of your own case. For more architectural risk awareness tips and new podcast announcements, sign up for our newsletter at prodemnity.com. If you liked this story, follow The Claims-Free Architect in your favorite podcast app. The original Prodemnity stories were written by David Croft and have been adapted for audio by Gordon Grice. The stories are performed by Liam Gadsby and produced by Revelator Studio, Toronto. The publisher and executive producer of the written stories and audio episodes is Prodemnity Insurance Company, Toronto. For more information, including the full legal disclaimer, visit prodemnity.com.